I propose to structure my response in...
Sorry, I thought Mr Duckworth hadn't quite finished.
I thought you had.
Well, no, my lady, I have, but really, if your lordship and your ladyship had a chance to read 60 and 61 and 62,
yes,
which is the material that shows the sequence of events
yes,
in terms of when the second respondent concluded his pupillage and started working as a barrister in 2017, then your ladyship and your lordship has all of the material which I say you have that you would need to make your determination as to whether there has been compliance with the live work planning permission as construed by me. So unless your ladyship or your lordships has anything else that you would like me to address in that context, then I think you do have my submission.
I just wanted to ask one question because I didn't ask it at the time. You said a number of times this morning, if I heard you correctly, that we have to grapple with the question of work and what it means on any footing.
Yes.
Why? Because if you're wrong on the and or, and it means or, then why do we need to concern ourselves with whether what was being done at this address was work or not?
My lord, you're correct in one sense. As I said at the outset, I'm not going to obtain the relief that I seek in the proceedings if I don't persuade you of that the oblique stroke means and, not and or. Because if it means and or, then purely residential use is okay. So in terms of resolving the appeal and resolving my entitlement to the relief, then I'm afraid I would be toast at that stage. But assuming I'm right about the oblique stroke, then one of the things that you've got to come on to consider, you do on any footing, then have to come on and consider the question of work.
Yeah, so if you're wrong on the first point you argued, I think as you did say at the start, game over.
It is game over. Your lordships and your ladyship have heard submissions as to what work means, and you may feel it appropriate to say what you think it means, even if you believe it's and or, and indeed this is a second appeal on the basis that this is a matter that raises a question of general principle. So you may wish to express a view as to what work does mean, but I accept that for the purposes of succeeding on my appeal, I don't get off the ground if I can't persuade you in relation to the oblique stroke.
That's very helpful. Thank you very much indeed. Thank you. Yes, Miss Stacey.
Thank you, my lady. I propose to structure my response in 5 parts. The first 2 I'll take rather quickly. I'll start by firstly addressing the law. And for that purpose, although there's not much between my learned friend and I think it is important for me to highlight the key principles in the authorities as to the construction of the planning permissions, which we say the judges had in mind when arriving at their conclusions. And essentially there we're talking about key contextual matters, incorporated documents, extrinsic evidence, public document points, but I'll take that quite quickly. Secondly, I will touch on how the judges dealt with the matter below and why we say the approach generally was consistent with those principles. By way of précis, we don't accept the characterisation that the conclusion reached by His Honour Judge Johns had an insufficient evidential foundation, or that he relied solely, or even primarily perhaps, but solely on one plan. There was more to it than that. So I'll skip through those quite quickly. Thirdly, then I'll turn to addressing the specific criticisms of the construction that Mr. Duckworth raises in his skeleton, and that will cover both the meaning of the oblique and the meaning of work. Fourthly, I then will touch on our respondent's notice, although it's been the subject of rather light touch this morning. And then fifthly, I'll say a word about breach.
Thank you.
So in terms of the highlighting the principles, as I say, there's not much between us. But if I could just take you to some of the authorities, in the order largely of the authorities bundle. So first we've got Trump at tab 6. and we refer to this in our skeleton at paragraph 29. It's been referred to more recently by the Supreme Court in the Hillside case. But tab 6, and specifically, if I could ask you just to note paragraphs 33 on page 123.
Sorry, paragraph.
Yeah, paragraph 33.
Thank you.
Whether words to imply depends on the interpretation of the words that have been used. And then paragraph 34 at the... Oh, sorry, just before I go to paragraph 34, further down the page next to E is the point that differences in the nature of documents will influence the extent to which the court may look at the factual background, the point about third parties having an interest in a public document, and so on. So there's only limited scope, it's said, against F for the use of extrinsic material in the interpretation of a public document such as a planning permission. And then further down that paragraph, just next to G, it's also relevant to the process that a failure to comply with a condition may give rise to criminal liability. And then the last line, this calls for clarity and precision in the drafting of conditions. The conditions are there, we say, for good reason. And then at paragraph 34, it's the question that's posed is what a reasonable reader would understand the words to mean, which is an objective exercise. Having regard to natural meaning, overall purpose, any other conditions which cast light, and common sense. And then whether the court may also look at other documents that are connected with or are referred to in the consent will depend on the circumstances, and particularly the wording of the document that's interpreting. And then one line just above paragraph 34 on that page, at the bottom, while the court will understandably exercise great restraint in implying terms, which will have criminal sanctions. No one's asking for the implication of a term, but that's the criminal sanction point again. And then at page 132, I could ask you to mark up paragraphs 65 and 66. 66 is referred to by my learned friend. 65 is simply the judgment of Lady Justice Arden and Carter, where she says that the planning permission is not to be construed like a commercial document, reasonable reader. And then there's a reference to the judgment of Mr. Justice Keane and Ashford, referring to the very strict limitations on extrinsic material that can be used in construing an application. And then paragraph 66, I would ask you to mark that up, which has already been referred to. At the bottom of that paragraph, there's reference to a cautious approach, or rather a relatively cautious approach, in the context of public documents. And we say precisely that was what the judge had in mind here. He was having regard to the context. Part of the context was this was a public document. If something is to be made mandatory, the risk of criminal sanctions would be expected to be spelt out. That's what conditions are for. The next authority is the case of Wood, that's behind tab 7. Judgment of Mr. Justice Lindblom. It's a decision which my learned friend describes as heretical, but we say it's well supported by authority. And what this judgment does is consider more generally the principles regarding the use of extrinsic evidence. And you see that from paragraph 40 on page 148. Which at the top of the page refers to the guiding principles of interpretation being clearly established, matters of law, and then 41, reference again to Ashford and to the judgment of Mr. Justice Keane, identifying 5 legal principles applicable to the use of other documents. And if I can just skip through them. Firstly, the general rule is that in construing a planning permission which is clear, unambiguous and valid, regard may only be had to the planning permission itself, including the conditions and the express reasons for them. Secondly, it's not appropriate to refer to the planning application itself and other extrinsic evidence unless the application is incorporated by reference, the reason being that the public should be able to rely on the document plain in its face without having to consider discrepancies. Now, pausing there, in this case, we say the application is incorporated by reference. Thirdly, if the application is to be incorporated into the permission, the words governing the description must make it clear that the application forms part of the permission. Fourthly, if there's an ambiguity in the wording, it's permissible to look at extrinsic material, including the application, to resolve that ambiguity. And fifthly, if a planning permission is challenged on the ground of absence of authority, well, that's then you can look at extrinsic evidence. That doesn't arise here. So those are the guiding principles. And at paragraph 43, the reference is made to the ability of a court to look at subsequent implementation. It's said, where it's necessary to do so, paragraph 43, permissible to consider extrinsic evidence beyond the available relevant materials as an aid, may relate to the way in which it's actually implemented, and references there made to Campbell. Just mark up that paragraph, you can tick every line. And then paragraph 44, analysis of the inspector's approach on the facts of wood, where reference was made to how this planning permission in this case was subsequently implemented. That approach wasn't in any way, it was said, inconsistent with established principles. He adopted what was described as a pragmatic approach, considered the planning permissions and in light of the applications and the drawings, but to enable himself to gain a full and accurate understanding, in particular the nature of the use, he also took into account a series of permissions for the whole development. So he used, in a sense, he applied the extrinsic evidence principles. And then over the page, at 46, it is said he also considered what happened on the ground when the development was constructed. At 47, I don't think the inspector went beyond the limits of a proper investigation into the meaning he had to construe. He was seeking to identify the lawful use under the several permissions implemented almost 50 years ago. It would have been artificial to confine his attention. And so on. He was, in my view, entitled to consider all publicly available documents and drawings in the several applications for planning permission which form the proposal, as well as decision notices. And he was entitled, at the bottom of that paragraph, to have regard to the development which in fact had been carried out. So that's wood. Take you briefly to the judgment of Mrs. Justice Leven in UBB. That's at tab 8. We refer to this in our skeleton at paragraph 31. And I think I need only take you to paragraph 52. Where she draws the threads together in terms of, you see in the preceding paragraph, factors. She describes them as factors, which she has applied to the issue. She notes that not all of them will arise in all cases. It depends on whether the commission or specific section gives a clear-cut answer. But the factors are set out from paragraph 52. Reasonable reader. On 52, she says, she makes the point that the reasonable reader will understand the role of the permission, conditions, and any incorporated documents. We say that the reasonable reader in this case, with some knowledge of planning law, would equally understand the role of a permission and understand that a permission to develop land does not impose an obligation. A reasonable reader would also understand, as per Sage, that there is an upper limit on the extent to which you can work in a conventional C3 unit, and would significantly understand the role of conditions and the relevance of incorporated documents. So have all that in mind when reading the permission. And as far as the role of conditions, which the reasonable reader would bear in mind, the point is this. In general, one looks at the words and one would expect restrictions, if there are to be such, to be spelt out in conditions. And I'll take you in a moment to the Manchester City Council case at paragraph 54, which makes good that point. The next case on this quick chop through is the Hillside Parks case in the next tab, the decision of the Supreme Court. paragraph 26 on page 195. Under the heading Interpreting a Planning Commission. Repeats essentially some of the principles which we've already looked at. And then paragraph 27 refers to the point about it being a public document. It says, 3 lines from the top, because a planning permission is not personal to the applicant and inures for the benefit of the land, it cannot be assumed that the holder of the permission will be aware of all background facts known to the person who applied for it. Furthermore, a planning permission is a public document which third parties are entitled to rely. These characteristics dictate that the meaning of the document should be ascertainable from the document itself. Other public documents to which it referred, such as the planning application and plans and drawings submitted with the application, and physical inspection of the land to which it relates. That's just a repetition and an endorsement of the principles that we've looked at before. And then the Manchester City Council cases at tab 11. And this decision is a decision of Mr. Justice Knowles, which considered the role and the importance of conditions. My Lords, this was a case involving appeals by the council against a decision of an inspector, which had determined an appeal by interested parties following the service of an enforcement notice. And what the council had done, you see this from paragraph 15, is had proposed some conditions to be attached to the grant if the appeal succeeded. That's the council's proposal. And paragraph 19, you see in the itemised bit at the bottom of paragraph 19, the extract, the inspector decided it wasn't necessary to impose conditions on the granted planning permission for specified commercial uses, and the council appealed. And you see that from paragraph 24. Paragraph 24, the nub of the council's submissions relates to the sentence that was itemised, which I just referred you to. The council argues the intention is to limit the uses as specified, but the council says, about 6 lines from the top, the council says the way in which the inspector expressed his conclusion meant that his was not given a legal effect and his decision was flawed. So that's what the issue was. And at paragraph 24 then, paragraph 44, we take it back up. Mr. Justice Knowles referred to the principles of construction per wood, and at 45, and this is the key for my purposes, there was a reference to the requirement for conditions in the grant of planning permission. It was said that any intended restriction or limitation on the grant must be expressed by way of condition rather than being built in. Now, we make this point, my lords and my lady, in our skeleton. We don't, below we were arguing a rather wider point, which was essentially that if there is no condition, you can't possibly construe a permission in a narrow way by relying on a description. We don't go that far. Mr. Justice Meade rejected that because he essentially said if you adopt that approach, then you can never have a narrow construction. It can't go as far as that. But what we say is that the absence of conditions is a powerful indicator in support of our more permissive, broader construction, and is entirely consistent with the Manchester City Council line of case law. And the next authority is Cherry Tree, which is at tab 5. So I'm asking you to go back in the bundle. And the question here was, as I'm sure you'll all be familiar with this case, but whether an erroneous omission from a registered charge could be corrected by interpretation. So the charge didn't refer to the facility letter that preceded it. And I need only take you to 2 paragraphs. 130 is the judgment of Lord Justice Lewison, page 104. Which makes the point that where there's 4 lines from the top, a publicly registered document which is addressed to anyone who wishes to inspect it, the knowledge of the reasonable reader would include knowledge that insofar as documents or copies were retained, they were to be taken as containing all material terms. So on the face of the register, you ought to be able to rely on the face of the register where the document is a public one. And then over the page, he goes on, there is in my judgment a real difference between allowing the physical features of the land in question to influence the interpretation of a transfer or conveyance, which we do, and allowing the terms of a collateral document to do the same, which we do not. And why I'm referring, my lady, my lords, to this is that the suggestion that it's proper to have regard to the SPG, we say runs contrary to the principle in Cherry Tree. It being not a document that was incorporated by reference. And generally speaking, the court should set its face against having regard to that kind of material to which the parties omitted any reference. And then 150 is the judgment of Lord Justice Longmore, which is essentially an endorsement of Lord Justice Lewison.
Would the SPG have been discoverable by the reasonable reader as the guidance? Was it on a website?
There's no evidence as to how public. I mean, the judge below, His Honour Judge Johns, was prepared to accept. That's as far as he went, that it was an SPG. I mean, we disputed that. We said there's simply no evidence that's been put for you. It formed the foundation of the appellant's claim, but for the purposes of the trial, he was prepared to accept it was an SPG. And there was reference, I think, in his judgment to a letter from the London Borough of Southwark referring to it. But in terms of its accessibility to the public more generally, we simply don't have any evidence as to how freely available it would have been.
But if he's accepted, I appreciate that wasn't your case, but tough.
Yeah.
If he's accepted its SPG, normally you would construe grants of planning permission next to obviously any adopted local plans, local development plans, and any special council policies.
Insofar, yeah, I accept that. As a matter of legal admissibility, yes. But the point is, we make 2 points. One, we say that it's not relevant because there's no hint in this planning permission that it had any material bearing. And when I come on to the SPG arguments, I'll say that one needs to be cautious about not attributing too much significance to it, giving it too high a status. But the second way we put it is that even if you do have regard to it, then it doesn't support the appellant's case.
Okay, well, there were lots of questions put on it to
Yes.
Mr. Duckworth.
And the general point is one, it's really an endorsement of the cautious approach. If one is being asked, as the bench is being asked in this case, to essentially import, we say, an interpretation that is to be found wholly in a document that's not referred to in the planning permission, that would be a very bold move. And that's essentially what Mr. Duckworth, his case depends on you essentially reading the planning permission in conjunction with the SPG and essentially transposing or importing the contents of the SPG or a meaning which he says to be found in the SPG into the planning permission.
I mean, it may cut both ways. I mean, it may be that if it's a public document and a reader would understand that if something is intended to be done by the council, certain conditions should be imposed because that's what it says in the document. And if they're not, then it may actually strengthen your case.
Indeed, but that's why I don't want to make too much of this because I say that even if we look at it, it doesn't help Mr. Duckworth and his position, and that's essentially what His Honour Judge Johns said. He said, I think there's no similarity between the absence of its influence. I think the words is striking. So yes.
But if the document is generally available to the reasonable reader, because it's available on a public website or in some other form, even on the basis of Lease Telecom and that approach that we've just been looking at, then it forms part of the relevant matrix against which the planning permission should be construed, surely.
Can I just say, sorry, my junior... Oh, I see. In our skeleton, we make the point that statutory plans have to be made publicly available. I think it's a footnote in our skeleton. There is no equivalent provision for an SPG, and that's what brings, we say, but I take my Lord Justice Dingemans' point that the judge was prepared to accept it was an SPG, but that doesn't take, that it does not follow from that you can necessarily assume that it would have been publicly available in the absence of a statutory provision that requires a local authority to make it so.
And there was no, I mean, there's no officer's report apart from the sort of handwritten note we've got.
No.
So, because normally these policies get into planning permission because the officer's report is part of the final decision or published with the final decision, and they specifically refer to the policies they've looked at.
Indeed,
Yeah.
but there's none of that here. We have the, if I could just put to bed one, I think, query about the delegated report at this stage, in terms of its availability generally. That document, I mean, I don't know, I can't say categorically whether it would have been freely available as at the date of the planning permission. What I can say is my clients, who is the very definition of a reasonable regio coming along after the event, a third party, obtained it. It was on the planning file. And that's one point. The second point is there's a reference, as I pointed out earlier, which is the same reference to the planning application, and therefore you can draw an inference from that, I say, that it's part of the suite of documents.
Can you, page 96 is grant of planning permission. Can you just identify what documents were referred to so that we can find
96 of, sorry.
Of the supplementary bundle? I think that's a grant of planning permission. Because there's reference to the Southwark Unitary Development Plan there.
Which doesn't contain, that's not the SPG.
But there's reference to the drawings.
There's reference to the drawing. There's reference to, so under planning permission granted, just above the address and the description, you've got a reference to alternative scheme to that approved under reference. So that takes one, that leads one, if one likes, to a trail back to previous planning permissions.
Hang on, sorry, where's that?
Sorry, above the word at and the address.
Oh, yeah,
So
thanks.
the descriptive bit. There's a reference that would set a trail running, if a reasonably were minded to follow it, back to the previous planning permissions that are contained in the bundle.
Because sometimes it's very helpful to have the screenshot of what the local authority had on its planning website, and then you actually know, but you know, this was all a different time, I thought.
You have reference below the address to the application received on the 1st of August 2000. So that's the planning application.
Is that in the bundle?
Yes, it is. And the date's foxing me, but thank you. Page 93. And then if you look at page 93, that's the planning application with the same reference number in the stamp on the top right-hand side. The second page, page 94, you see a list of drawings and certificates, documents, etc. That includes Plan P304D, which is the one that was subsequently swapped out, so the one with the pink and blue. So that would have been available, as would the subsequent substituted plan, which when one goes back to 96 of the bundle, is then referred to as P404A. And so far as the delegated report is concerned, which is at page 95, you've got the registration number, reference to a case officer. There's reference to the report having been printed, so it's a document that existed in hard copy form. And you've got the same wording in terms of the proposal, including the bit in square brackets. So we say all of that points to, well, that in terms of what was available, you have the plans that were included, including the substituted plan, and it's the original plan. It's a reasonable inference that the delegated decision report, being part of what I describe as a suite of documents, would also have been available. Nowhere in there do you have any hint of any reference to the SPG, which, as we say in our skeleton argument, there was no statutory requirement to make publicly available. So there's a question mark over the extent to which it would have been publicly available. But my backup case is if you do look at it, it doesn't assist the appellant. Whilst I'm in the authority, just before I turn to the judgment, I probably should refer to authorities which are relevant to the respondent's notice point. I've referred to Wood. My lady, my lords, you've got the Wood PTA judgment, which no issue's been taken to my entitlement to refer to it. That's the decision of Sir Ernest Ryder, Senior President. And if I could just ask you to take that up. Do you have the hard copies? Because if not, I can hand some up.
I did this morning.
Well, I've got 3 copies here.
Thank you.
So this is a decision appealing the Wood judgment. Paragraph 12 sets out the Secretary of State's case, which we essentially adopt here. 12. So we adopt that submission in paragraph 12. And then the analysis is to be found in 13, 14 and 15. 13, agree, having had reference to the authorities, it's undoubtedly the case the court had reference to plans as well as decision notice, looked at the implementation of the planning conditions. That was what was done. Paragraph 14, was it permissible? Is there a reasonable prospect of success? Say not. And then it's paragraph 15 that was justified on the facts of that case. And the use of those extrinsic materials didn't extend beyond that which was permitted in the authorities. No error of law.
What is in the past history of or later history of the site relevant from that anyway?
In terms of our case?
Yeah.
Well, we say that it's we say that the principle that you can extract from Wood is essentially that where there exists objective material which is of probative value in terms of illuminating the meaning of a planning permission, that is material to which the court is entitled to have regard for the purposes of that illumination. It's not conclusive. You can't go too far, but that if that objective material exists, then it's within.
But what is the objective material?
The kitchen. It's the client, how it was implemented. So how the unit was in fact built. So on the plan, we'll recall the kitchen was anticipated to be in the northern half, and I think my Lord Justice Snowden said that when you're comparing the 1999 plans and the 2001 plans, you might say that the latter was more conducive to working because you've got a big unit at the bottom. But in fact, what the judge found was that as implemented, the permission put the kitchen in the southern part, which takes away some of that. So that's the position on the ground. And
I mean, you're a million miles away from Wood, where
yes.
you're talking about looking back into history and how that was developed. The point is, we all know some people breach planning permissions almost as soon as they've been granted. And Wood is not authority for the proposition that you can go and look at that and say that's fine.
No, and I'm not suggesting for a moment that that's the position. but insofar as there was considered to be ambiguity, and bear in mind also we're looking at a situation where you've got a planning permission that's contained in a lease, and it's not a heresy, and it's perfectly conventional for a lease to be construed by reference to the physical features in existence at the time. What I'm really saying is that there was no error of approach by the judge for a number of reasons. One, he wasn't doing what Mr. Duckworth complains of. Two, he was looking at the lease. And three, in any event, when one looks at wood, it is permissible, at least, if there's ambiguity, to have regard to it as a kind of cross-check. So it's for that reason that I took you to that authority. So secondly, dealing with the approach of the judges, it will come as no surprise, as we say in our skeleton, that His Honour Judge Johns was correct for the reasons both as he set out and also those set out by Mr. Justice Meade. Both judgments consist of a careful examination of the relevant planning permission, and their analysis contains no error of law. And the judge's conclusions and their approach are entirely consistent with how we have said in our skeleton at paragraph 36 the planning permission should be construed. As I alluded to earlier, the appellant, we say, mischaracterises the judgment when he suggests that the judges only refer to the plan. I'll take you to the judgment when I deal with the first criticism, but you'll see that it's not simply limited to one plan, but looks at the whole of the planning permission, including documents that formed part of the proposal, and including what was not contained in the planning permission, and that's an important point. The overarching point is that we say that the judge's conclusion was consistent with authority and coherent, and that the permissive construction properly reflects a number of things, which I'll outline now. The first is it reflects the fact that, as accepted by the appellant, live/work is capable of being construed in a permissive way without more, and so as not requiring both uses. And that's a point His Honour Judge Johns made at paragraph 27 of his judgment. So it's capable of being construed. The point is, if you want to make it mandatory so that the reasonable reader can understand it, then you need clear language. Secondly, the approach properly reflects and recognises the fact that the question of whether a planning permission actually secures the integrated living and working depends not on the use of the label live-work, but on the terms of the particular planning permission. So each individual planning permission and any conditions imposed, construed on their own facts. We say the devil is in the detail, and you'll be well aware that every planning permission, as I say, is individual. It involves an administrative making process, and the decision maker will decide what weight to give to various policies. Thirdly, we say the judge's approach reflects properly what was contained and significantly not contained in this planning permission, especially the absence of demarcation, conditions and stipulations. Fourthly, we say that the judge's conclusion properly recognises that as the planning permission is a public document, a mandatory construction would need to be clear on its face so as to be readily understood, bearing in mind that breach would carry criminal sanctions. And it's not just the criminal sanctions, it's also the risk of an injunction in circumstances where the obligation is contained in a lease, which is precisely what my clients have been found, been forced to face in this case. One can't, as I think Mr. Duckworth sought to do, downplay potential ramifications of criminal sanctions hanging over the reader's head. And then finally, the conclusion properly recognises that a permissive construction is less problematic in terms of uncertainty. In our skeleton argument, we posed a number of questions. That's at page 167 in the footnote, it's footnote 89. There's a number of questions we posed as to what the meaning of the appellant's construction was, somewhat aligned with the questions that the Lord Justice Snowden was asking. But yes, there's uncertainty to some extent on both sides in terms of one needs to give the meaning, but that uncertainty only really arises in practical terms in circumstances where my clients are being sued for breach and being asked to do something specific. So with that summary, I'll turn to my third section, the specific criticisms and suggestions that the judges went wrong. The first criticism is that it was said the judges went wrong because they thought, or His Honour Judge Johns, thought the ambiguity as to the meaning of the oblique stroke was resolved by one of the plans, and that's a quote. And that's the appellant skeleton, paragraph 2.1 and paragraph 18. That's a misconception. It's clear from the judgment that His Honour Judge Johns didn't simply rely on the plan. Paragraph 27 of his judgment, you can turn to that. Behind tab 13, on page 264. After having identified what's accepted was the correct starting point, namely that it's capable of meaning a permissive use, he then says, third sentence, that is principally because the nature of the premises is shown in the plan. So that wasn't the only reason for his conclusion. And then at paragraph 31 over the page, he refers to the fact that overall this planning permission premises, as appearing in the plan, make up a different animal. The plan was certainly a critical part of his reasoning, but it wasn't the only part, and that's the point that was made by Mr. Justice Meade at paragraph 24. And
which plan are we looking at there? That's
in
page...
paragraph 31.
Yeah, is that...
As appearing on the plan, that must be 404A.
Which is page 104.
Which is page 95. No, 96.
No, it's not 95.
No, not 96. It's page...
I think it's 104.
109.
109. Yeah, thank you.
That's page 109. But the point I wish to stress is the starting point at paragraph 27, going back a page. Once that starting point has been identified, we say it follows that you can give the term live work the permissive meaning if there is no indication in the planning permission that it is intended to be mandatory. And what His Honour Judge Johns was doing, I suggest, was searching for whether there was in fact anything in this planning permission that supported a mandatory construction. So in terms of his analysis, you start at paragraph 18. 261, and he makes the point that the plan looks like a flat, a conventional flat, nothing to show a dedicated workspace. He refers to, I should say that there was no need for him to look at the SPG to form that conclusion. That was simply his comment on the physical characteristics of the flat. He then refers to the fact in paragraph 19 that the whole area is shaded. Mr. Duckworth suggests that's entirely bland or neutral because there's nothing to show that the whole couldn't be used for business. But that's, in my submission, respectful submission, missing the point. It may mean that there's nothing to show that you could not use it for business, but the point is that there's nothing to show that it had to be used for business or work. And so far as the point about it being essentially a shell, and that it would be up to the buyer to configure it, if you like, as they see fit, that we say doesn't get the appellant where they need to be. because firstly we don't accept it was really a shell because you've got the kitchen in the southern part point. But the fact that it was capable of being used for work by virtue of it having been a shell would not be enough, we say, for the reasonable reader to conclude that it was intended to be mandatory. Work was intended to be mandatory. The point was that no part had to be used for work, and there were no conditions requiring that. So as I say, the shell point may be neutral so far as whether business use was to be made, but is not neutral as to whether business use had to be made. And in relation to the suggestion that it would be up to the buyer, we say this: the absence of a condition fits rather uneasily, we say, with the fact that this is a public document that would be readily capable of being understood. There's no guidance for that buyer. And it would also be an unusual type of mandatory obligation to require a buyer to decide without knowing what compliance looked like. So how would a buyer know how to fit it out and how much to use? In the absence of any stipulations or conditions, they're entirely in the dark. So going back to the judgment, it's notable, as one sees from paragraph 18, that the judge also had regard to two other matters. Firstly, the officer's comments, which is referred to in paragraph 18. In relation to that, we say, as will have become clear, that he was entitled to refer to that as part of the suite of documents forming the proposal in line with Trump principles. Same reference number, and it was admissible. I've made the point that it was a document that was obtained by my client. And if one reads that document, which is to be found at page 95, it is quite clear on any deconstruction of the words that what the officer was saying, in the position essentially of a reader of the plan, someone, as Lord Justice Snowden said, had experience, but someone construing the plan was saying that this is essentially a flat. And it bears no similarity to a genuine live-work business unit. Now, by that, I suggest what he meant was a mandatory live-work business unit. So a live-work business unit that required work.
Well, it's apparent because he says this is an application for 15 flats.
Yes.
The only way you get to 15 is by treating this as a residential unit. See the top of the page.
Yeah, he's saying, and one of which being a reference back to.
Yeah, he's adding 14 in one.
Indeed. So someone with experience reads the plan and reads it in a manner that's entirely consistent with the way the judges read it. As far as he was concerned, this was not a mandatory live-work unit in the sense contended for by the appellant. And the plans weren't changed. We don't know what happened between the date of this document and the grant of planning permission. Don't have any subsequent report. We don't know how the affordable housing situation was resolved. But what we do know is that the plans weren't changed.
So what do you say to Mr. Duckworth's point, which is, and that means that they really intended live work because they specified live work on the planning permission?
No, we say what that means is, back to the starting point, if it's capable of being construed in a permissive way, which was acknowledged below, what this does, you still have the label live work, but you have to apply the permissive construction of that, the flexible, protean, broad construction. And essentially, the way it was put below was this is essentially live plus. You can live there, but you can also work there, and you can work beyond that which would be permissible under a see-through use per sage, because there's always a cap beyond which you can't go. And that was the planning purpose which was identified by His Honour Judge Johns in his judgment when he did a cross-check as to whether this still serves a planning purpose. That's that paragraph 30 on page 265. says, yet further, a permission construed in the way contended for by the defendants, that's my side, would serve a planning purpose by encouraging increased work use by allowing a level of work even running the business which went beyond that which would be permitted by C3. So in a sense, it's live plus. So the officer's comment was relied upon in addition to the plans and the absence of conditions. And then it's also apparent from the judgment that the judge, back to paragraph 19 on page 261, that reliance was placed on the contrast with the earlier plan, which, as I indicated, had been incorporated by reference in the original planning application and swapped out. And the contrast that was drawn was that the original had contained the demarcated sections, whereas the substituted plans had not. And that, what one takes from that is that there had been a conscious decision to move away from demarcation to the plan we find at 109, which has the whole of the area shaded work live, with no suggestion that any part could not be used solely for live, or that any part had to be used for work. And we say, when you look at those two plans and contrast them, that the only sensible deduction that the reasonable reader could take is that delineation wasn't intended, and that this was a different planning permission from that which had been contemplated in 1999, not a mandatory work-live unit.
Well, the shading and the demarcation is done by the person submitting the application, isn't it?
Yes.
So you have to link the fact that the council approved planning permission of an undifferentiated plan.
Yes, I do, but the plans are part. There was a grant. It was granted, and the plans weren't changed.
Yeah.
Not only that, there was a substitution. There was a comment by the officer, so it was on. He was aware of it, and the plans weren't changed. Then there were no conditions.
This is where one of the benefits you might get from looking at the SPG as part of background would be to emphasise the importance of demarcation in planning proposals being approved.
Yes.
I.e., if the council says if you want to have non-abusive, as they would put it, live-work properties, you have to impose conditions and you have to ask for clear demarcation on your plans.
Yes.
So if you get plans that come along that are not clearly demarcated, especially when previous ones were.
Yeah. Well, there are 2 points there. One
there's a number of points rolled into one. In
yes.
fact, but
I mean, I'd say drawing them out that if there's in the absence, what we're looking at here is whether this is a permissive type of live work or a mandatory type of live work. And my primary point on this, without even looking at the SPG, is because it's capable of being construed in a permissive sense, you need the more, if you like, in order to make it mandatory. And then on the SPG, there's a problem for local authorities in terms of enforcement, because even if they try and make it mandatory, because the planning permission might be rather different and have, maybe say, just be deficient in other ways, capable of being construed in a mandatory way, which ours isn't, but doesn't contain the clarity that one would expect to have, that might cause problems for the local authority in terms of enforcement. But we don't get anywhere close to that, I say, because this is a permissive type of live work. And therefore you default to the notion that it's suitable for living and or working. Now, I should probably deal with the alternative suggestion that Mr. Duckworth made, which was that you can deduce from the contrast between the two plans that it's intended to be a less restrictive type of mandatory live work. But the problem with that is, what does that mean in terms of the reasonable reader? And then we come back to the risk point of criminal sanctions, the public document point, that it should be clear on its face. And for all of that, one doesn't need to look to the SPG. So after having referred to the substituted plan, His Honour Judge Johns also refers, at paragraph 28, to the other plans, namely Plan 403B, which included the key. You were taken to that. I just need to... and specifically, yes, so on page 109, you see in the unit adjoining Unit 8, the label office/B1. And I think Mr. Duckworth's point was that the judge fell in error here because he looked at the way in which the oblique had been used in other places and said that it was not consistent with the and or construction that we were contending for. We don't accept that. So, for example, if you take the office/B1, office extends beyond B1. We don't have the use classes order here before my lady and my lords, but when we could obtain it, that would be helpful. But office use extends beyond B1. B1 might include certain types of offices, and my understanding is industrial. Yes. But it also includes other activities which extend beyond office. So office, if it were to be construed as office and B1, that would make less sense than office and or B1. And therefore we say the construction by His Honour Judge Johns and Mr. Justice Meade, when he looked at the other plans and said they were more consistent with the permissive use of the oblique, was entirely appropriate.
Which paragraph of the judgment was that?
So paragraph 28
Thank you.
of His Honour Judge Johns, and then Meade. Would you be assisted by the reference Meade?
No, thank you.
So there was no lack of consistency there. And finally, at paragraph 29, His Honour Judge Johns referred to the context quite properly, in line with Trump decision, and specifically paragraph 57, about breaches potentially leading to criminal sanctions, and made the perfectly sensible point that parties need to know when they've done wrong to understand what compliance looked like. So essentially what we say the judge was doing here was having regard to the absence of conditions. And all of that stacked together, the officer's report, the substituted plan, the plan itself, the shading, the other plans and the use of the oblique, and the context, provide, we say, ample evidential foundation for the judge's conclusion that there was not the more in this planning permission that would need to be present in order to give live, work a mandatory sense. And on that basis, it was perfectly appropriate for the judges to confine themselves to the planning permission and not look further. The third criticism, or actually the second criticism, I think, is that the judges were wrong to conclude that reference should not be made to the SPG. I should deal with that now. We deal with this in our skeleton at paragraph 45. And I've already made the point, which I hope takes me some way to where I need to be, which is that there was no need for the judge to look elsewhere. His rejection of the SPG was perfectly in line with Trump at paragraph 29, which refers to having reference to incorporated documents, and where documents are not incorporated, the court should generally set its face against referring to them. I've made the point about the question mark as to accessibility and public availability. And as Mr. Justice Meade put it, ambiguity permits but does not mandate the use of extrinsic material. There was no error of law there. The next criticism is that when one looks at the SPG, that puts the matter beyond doubt that living and working was required, and that is said to have been self-evident, and that's paragraph 35 of the appellant skeleton. This obviously only arises if the judges were wrong to reject the relevance of the SPG, and we deal with this in our skeleton at paragraph 46. But the suggestion that it would be self-evident that the reasonable reader would conclude that live work was mandatory if one read the SPG in conjunction with the planning permission, we say is plainly wrong. It's unsustainable. And I draw out three specific points. In addition, I'm not going to, unless you want me to go through the skeleton, but three specific points. First is that even if one were to look at the SPG, one can't overstate its weight. One has to look at it in the context of this particular planning permission and compare the planning permission as against the SPG. You can't import contents of an SPG if that is not reflected in the language of the planning permission itself, or if, as His Honour Judge Johns said, the absence of any influence is striking. That's the first point. Second point is that the SPG does not define live/work. It is not so precise as the appellant would contend. It is a vague concept. And so even reference to the SPG does not support the suggestion that the purpose must be mandatory. Indeed, when one looks at the language of the SPG, it's apparent that domestic scale activity or single person operations, essentially working from home, are not outside the letter of live work, even if they may not be within the spirit of it. So it's not such a hard-edged prescriptive concept. And we've looked at the SPG. I'm entirely in your hands as to whether we go back to it.
So it's entirely up to you.
Entirely up to me. But I'll do it quickly. So if we look at 3.1, which is supplemental bundle, tab 4.
3.1.
3.1.
Page 74.
It's described as an advisory document, so by definition, guidance, advice. 3.2 refers to the spirit of the above recommendation. 3.
Sorry, were you equating this Bermondsey Street Action Plan with this document? Because you said it was advisory, see 3.1.
So I say in 3.1, oh, I'm so sorry, you're absolutely right. It was published as no, that was the.
I think you need 1.1.
I need 1.1 exactly. I'm grateful. 1.1 is advice, and indeed it's referred to as guidance. So
Yeah, no, that's fine. It's just I couldn't follow 3.1.
you're absolutely right. That was a false reference. 3.2 refers to the spirit of a recommendation, and in the last sentence before the colon, generally for the following reasons. So it seems it's not, as I say, hard-edged. 3.3.2 refers to single person operations which don't create employment, can take place being not within the spirit again of live work and not being encouraged. So there's a distinction between something not being within the letter of this guidance and not being within the spirit of it. So the scope, we say, of live work, even when one looks at this SPG, is sufficiently broad and protean that it would extend to single operations in the absence of the bells and whistles that one would need to include in order to make it not so. 3.34, my Lord Justice Snowden's point, appeared to allow single person use to operate legitimately. That's even in circumstances where there are conditions. What they're saying in that paragraph is you need to impose conditions in order to make it illegitimate. And in our case, if there are no conditions whatsoever, we don't get to the enforcement stage.
You need to impose conditions referring to a defined area. That's what it says. So if you have no conditions at all, then mind ones that don't refer to a defined area.
Yeah. Well, then you're well within the permissive.
appears to allow people to operate legitimately, and as a consequence, or as a necessary follow-on from that, it's difficult to enforce conditions which don't refer to
A defined
areas.
That's the practical problem.
Yeah.
Yeah. But in the absence of conditions, it's not mandatory in the first place. And then 3.35, there's a reference to the domestic premises and council tax points, business rates. This fact may encourage abuse of the lawful use of approved live-work units. Well, it all depends on the fact. It may encourage, but it seems to me one can't draw from that anything more than, there's a potential there, a risk that's being identified. The scope is broad, so that's the second point. It doesn't define live work, it doesn't require it to be mandatory, the scope is broad. And the third general point I'd make is that in this particular case, there are a number of clear indications that this SPG was in no way a material consideration. The guidance makes clear that one needs machinery in order to control use. It contemplates the use of conditions which would be needed in order to mandate living and working, and design criterion which are said to be required. And His Honour Judge Johns noted that at paragraph 35 of his judgment. When he says, far from being a document incorporated, the absence of its influence seems to me striking. There's no trace of the requirements that the SPG contemplates. And he goes through them. And in terms of the requirements, if you still have the SPG open, if I could ask you to refer to paragraph 1.4, which refers in the second sentence to a range of requirements that will need to be met, as well as conditions that are likely to be attached. So the requirements are necessary according to this document. And then over the page at page 74, 4.2.
Sorry, I didn't get your reference. Needs, is that the penultimate line?
Yeah, this guidance, 1.4, this guidance sets out the background. It identifies a range of requirements that will need to be met by live work developments. I've placed emphasis on the words requirements that will need to be met. And then I'm about to take you to the requirements. At 4.2, under the heading requirements. The last line, the council will therefore expect the following requirements to be met. And then 4.2 refers to design. 40 square metres of definable functional workspace. And then 4.2.2 we place emphasis on because it refers specifically to a shell scheme, which the appellant says this is, needing to be subject to a condition, will be subject to a condition requiring detailed drawings of internal layout. None of that here. And then 4.2.5 needs to be capable of accommodating the whole range of B1 uses, including light industry, easy access, double doors of 2 metre width. None of that here. And then in addition to those requirements, you've got the conditions at paragraph 5. 5.1 should be attached. And then 5.1.2, you've got a condition that will usually be included when live work units are improved. Requiring the submissions of internal layouts. And the second condition is about occupation and the purposes for which the unit should be occupied in order to ensure the authentic use. Now all of that, that's what I describe as the bells and whistles, but it's the mechanics, if you like, the machinery in order to mandate. That was well within the local authority's gift, but none of that featured here. So His Honour Judge Johns was perfectly right to say there's not a trace of what the SPG contemplated in this planning permission, which underlines, he says, the impression that we're not dealing with that kind of mandatory live work. Here, it's essentially flat. Before I leave the criticisms, I should deal with three, very briefly, submissions that were made by appellant. The first is the point that live work should be given a single consistent meaning across the London Borough of Southwark. We say there's no reason for that. I've made the point that each individual planning permission is an exercise in administrative judgment call. Yes, it's the case that their live work doesn't fall within a use class, so in that sense it's sui generis planning use, but that's as far as it goes. In the London Borough of Southwark, as I said, it's in the gift of the particular local, the decision maker, to decide what weight to give to particular policies on the facts of each individual case. And it's not at all surprising that, as Mr. Justice Meade said in paragraph 23 and 27 of his judgment, that the concept is sufficiently flexible to be capable of accommodating different activities, even within a single borough.
Presumably is why there was a specific guidance document for live work development in the Bermondsey Street development.
Yes.
Because that might have different conditions and different desire to create a different type of feel or overall use.
It provides
other
the
parts
necessary
in
flexibility. Yes. Yes, it's not prescriptive.
In other words, this guidance isn't to cover the whole of Southwark.
No. Indeed, in Bermondsey, exactly.
I mean, sorry, beg your pardon.
And Mr. Duckworth refers to, he draws in an analogy, if you like, in his skeleton argument, saying, well, a hostel, for example, is a recognised term, a term of art. That's not the case. The case of Ipswich Borough Council and Fairview, which is in the authorities bundle, says as much. Mr. Justice Holgate says that it depends on the facts, and there's a degree of flexibility. It's a question of fact and degree. So even the example given by the appellant doesn't have one single consistent meaning. But even if it did, shop, there's no reason to elevate live/work to a term of art. The second submission that I ought to deal with is the contention that the reasonable reader would have knowledge of private law, and that would feed into the analysis. The point being that, well, if you don't construe it in a mandatory way, then it leads to some uncertainties as to what the interrelation might be between, is it a flat, is it a workplace, with regard to landlord and tenant commercial statutory regimes. We deal with this in our skeleton, but essentially I make 2 points. First is that the private law regime is not legally relevant to construction of a planning permission. No aid to construction, and wouldn't be relevant to the reasonable reader. And we get that from the Westminster case, which is at tab 2 of the authorities bundle. At page 670. Internal page 670. So I start, just to put it into context, on page 39 in the head note, the question being posed was, what was the test of a material consideration in the preparation of local plans? That's next to B in the head note, next to held. And next to F on the same page, per curiam, rights relating to the use and development of land, including those of landlords and others interested in land, take effect subject to the controls imposed by planning law. So planning takes subject to private law, not the other way around. And then at page 670, internal page 670, if I can ask you just to mark up C through to D, which starts with the test, therefore, of what is a material consideration. Whether it serves a planning purpose. And then next, just below E, personal circumstances, personal hardships, difficulties of business which are of value are not to be ignored. And then just below F, it can, however, and sometimes should be given direct effect as an exceptional or special circumstance, not as a general rule. The point here is that private rights are only exceptionally relevant, or private circumstances. And then on the next page, next to E, sentence starting there remains the point on the Landlord and Tenant Act. It is, in my judgment, based on a misconception of the relationship between the planning legislation and private law. Rights to the use and development are now subject to the control imposed by planning law. The rights of landlords take effect subject to planning controls. So we say not legally relevant. We also say you can't expect the reasonable reader to carry out a forensic cross-check of planning or private law implications to work out the likelihood of something being mandatory or not. And then finally, we say that even if you assume the awareness and it is legally relevant, then only minor weight can be given to it in light of Westminster. And on the basis that when a developer is being granted planning permission, the developer would not necessarily know how the unit would be disposed of. So these private law regimes come in, for example, in the landlord and tenant context, where there's going to be a lease, but the developer might not dispose of the unit in that way. They might retain it for themselves, use it as a head office. They might license it. They might grant a short-term tenant.
I'm not sure what point you're making there. I mean, in this case, the case against your clients is founded upon the terms of a lease. The lease expressly refers to the user in the planning, in relation to in the planning permission, doesn't it?
Yes.
So I'm sorry, I'm not sure where we're going.
I was looking purely from the perspective of looking at the planning permission, the reasonable reader of a planning permission. You're quite right, outside the context of the lease. It's the question, I understood the point being made against me was that the developer or the reasonable reader looking at the planning permission alone would be assumed to have had knowledge of the broader landlord and tenant context, a form of view as to how that would square, if you like, with whether or not mandatory or permissive.
But in this case, it's the other way around. If, contrary to your argument, on its true interpretation, the planning permission said that you had to use this unit for living and working, your clients are now the tenants of a unit which, according to the lease which they have taken, must be used for living and working, because it cross-refers to planning permission. So I don't understand how we're getting into this current argument.
Fine. Well, that may not be helpful. But I say my primary position on this is that private law regime is irrelevant effectively to the question of construction. It doesn't in any event tip the balance. It's not something that the judges relied on. Yeah. They didn't need to, insofar as there's any potential uncertainty. The question of whether you fall in or out of a landlord and tenant situation under the 1954 Act is a question of fact and degree.
But I think Mr. Duckworth nails his colours very firmly to the planning permission mast. I mean, if he's either right or wrong on that.
Yes. Which means that I can. There's all the third submission was the mistake. It said that the judge made the mistake of deriving support for the conclusion based on the position of the kitchen. I think I've dealt with that point, so I can move on to the final point in terms of criticisms of the judge's approach, which was that the judges are said to have been wrong in their construction of the term work, and they should have found that work equated with business, and to have found that business did not include non-commercial activities such as charity and voluntary work. We address this in our skeleton. Essentially, our position here is that the judges were perfectly correct to give work its natural meaning. It's a wide concept. There's no reason, we say, to conclude that it equates to business. The concept of running a business is very different from the broader concept of work. And as Mr. Justice Meade said, there's no justification for substituting one word for another under the guise of interpreting words. Even the SPG is not so prescriptive. As Mr. Justice Meade pointed out, it envisages a range of activities, a spectrum.
But they're all income generating, I think, is what Mr. Duckworth says.
They're all income generating. Yet they might, well, as a matter of fact, they might not be. So, for example, an artist might not generate income because they might be trying and starting out. So once one starts introducing concepts such as it has to generate income, one falls into the trap, I suggest, of too much uncertainty. Mr. Duckworth posed the question that, he said, the question is, where do I work? I suggest that's the wrong question. It's not where I work, or where I work for most of the time or for part of the time. It's, am I using the premises for work, which is what the covenant says. You cannot do anything other than use the premises for work. That does not require me to establish that I work there 100% of the time, 50% of the time. And when one starts posing those kinds of tests, the uncertainties start revealing themselves. My side was in a sense criticised for not having articulated what our position on work was. The critical distinction here is that we're not seeking to work. And we're essentially saying that work is wider than business. So if we're required to do something under the label work, which we say we're not, then we're within it. It's wide, not narrow. And more than negligible is enough in the absence of any stipulation to the contrary. So the suggestion that the uncertainty point arises to precisely the same extent on our construction misses the key point that we're not the ones suing for breach. And when somebody is suing somebody else, another party, and specifying that they have to do something, there needs to be the precision so that that other party can understand precisely what it is they're being asked to do. And that concern doesn't arise the other way round. So it's not precisely the same. And as Mr. Duckworth, I think, recognised, you needn't grapple with this point in any event if we're right on our primary position in terms of the mandatory versus permissive construction.
I mean, isn't the easier question to ask, in a sense, is it living? In the sense that if you delineate the work, if you delineate, as the SPG suggests you should, workspace from the residential area, then it becomes easier to identify whether the use is in accordance with what you wish as a local authority. Because it's easier to tell whether somebody's living in a space than to answer the question of whether it's work or business.
Indeed, it's more difficult the other way round.
Yeah.
Because one could occupy a desk in the corner of a living room and set up a computer and use that space. It's not clear if, say, for example, a local authority enforcement officer came along and looked at the space in the absence of a designated work area, it would be, we say, extremely problematic and difficult for them to understand whether or not there was a breach.
But if there's a designated workspace and you turn up and you find there's a bed, a TV, I don't know, with a video game controller attached, etc., you might well find it quite easy to figure out that whether you called it work or business, it wasn't being conducted there.
You're not doing any work there. But then it becomes subject to an inquiry as to what precisely is being done in the space.
Yeah.
And on that point, in terms of breach, I mean, to answer my Lady Justice King's question, we don't accept there are any bright lines here. On the evidence, even the evidence relied on in the unagreed bundle by the appellant, it's mix and match. And it doesn't follow, we say, that the fact that some work has been done on a voluntary or charitable basis does not follow from that that's not business, because one can supplement one's reputation, one bolsters one's profile under the guise of business. And once there was no finding by the judge that all activities done within the premises were non-charitable, non-commercial or charitable. It's all a question of degree. So there would need to be a proper inquiry. You need to strip out the impermissible parts. And whatever the test is, then there would need to be an evaluation at that stage. We also say that it's not appropriate to cherry pick bits from transcripts and bits from witness statement in circumstances where the transcript is incomplete. There was also evidence about trading, which doesn't feature in the Anagreed bundle, and excerpts which, if one were to make the points, would provide a more complete picture. So it's cherry picking out of context at this point in time is, we say, inappropriate. Just before I leave work, Mr. Duckworth relies on the case of Jenkins, I think, to support his proposition that work means business. That's in his skeleton at page 131. Jenkins is at tab 3. You weren't taken to it, so it may be unnecessary for me to take it. I'll just make one point on it, which is that was a case dealing with section 23 of the law of the Landlord and Tenant Act 1954, which is concerned with whether or not premises are being occupied for the purposes of a business. It's a specific statutory regime. They weren't dealing there with use of premises for work. And there's no reason to restrict work to business. Entirely different context. And the attempt to equate use for work to that statutory definition, we say, is unjustified. I think that brings me to the end. I can just turn my back. Just so we're absolutely clear, going back to my Lord Justice Snowden's point about the statutory regimes, just so in case I've mischaracterised our position, can I just ask you to look at how it's put by the appellant, page 128 of the core bundle. This is my final point. Where it said that the reasonable reader would be aware of the various statutory regimes that might apply, and would consider the extent to which the rival readings would fit into those regimes. The submission is broad, so it's not simply a question of looking at the lease, but it's also looking at, if you look at the footnotes.
So this is what took you into your argument about private.
Indeed, and that's back to my argument about private. So there's no reason why, A, the reasonable reader would be equipped with all that information, B, it would be relevant, but the key point, the primary point is planning takes subject to.
Something in reply.
Lady, just a few points in reply, if I may.
Certainly.
Just sticking with the big ticket points, really. Much of my learned friend's submissions amounted to an invitation for you to follow the judges below in their approach in simply not having recourse to the SPG at all. And I suggest, as I think in a way my Lord Justice Snowden was suggesting, that leads to an intellectual cul-de-sac, because if you are restricted to the documents that are the text of the planning permission and the plans that it incorporates by reference, you are left with a position where the linguistic uncertainty is simply not resolved by looking at those plans. And in a sense, she has to expand beyond the four corners of the planning permission in order to find material, in order to positively promote a live and or work reading of the planning permission. And I think that must be right, that if you are left with simply the planning permission and those plans, you don't get to a decisive result in the contest between the three different representations of the oblique stroke, or three different meanings of that. A related point is she doesn't accept that this was a publicly available document. And what I would say about that is, if you look in paragraph 1.1 of that document, it says that it is advice intended to be used by developers in making future applications for live-work planning applications. It would be extraordinary if that document were not made publicly available. And indeed, it would be an entirely self-defeating form of supplemental planning guidance for one to be produced but not promulgated to the public at large. So asking yourselves, is this a document that's publicly available? The logical inference from the very nature of the document and its opening line is that it is. So let me move on to make my next point. I listened with interest to the point at which my learned friend stopped criticising the logical sequence that I've taken and commenced setting out her positive case as to why live and or work is the meaning of this planning permission as it would be understood by the reasonable reader. And what she said in relation to that is interesting and bears a bit of careful consideration. She says that His Honour Judge Johns concluded that as a matter of language, live work could mean live and or work. No problem with that proposition. But she goes on to say that permissive, that broad and permissive reading of the oblique stroke is what this planning permission means, unless there is some indication in the planning permission that the business element, the work element, is mandatory. And if you can't find that, then she effectively says that the default position is that the meaning of the term live-work unit is the permissive and or one that she is promoting. That seems to me, in my respectful submission, to be circular thinking. It takes as its starting point really that which she sets out to prove, which is what does the meaning of the oblique stroke mean, and it is not supported in my submission by authority or by logic. There is no default position. You should approach this question of construction with no preconceptions as to the right answer when it comes to unravelling the linguistic ambiguity in the oblique stroke. Learned friend is not right that she starts in the box seat unless I find some material that enables me to lever her out of it. And where does she get that from? Well, she took you to a number of passages in the authorities, but they're not authority for that proposition. If I could just briefly take you to back to Trump, I think that what learned friend was resting on was the statement in paragraph 23 at the very bottom of the page. It's relevant to the process of interpretation that a failure to comply with the condition may give rise to criminal liability. And I think she places a certain amount of emphasis on that as being supportive of her basic proposition that more permissive of two readings is generally to be preferred because of the risk of criminal sanctions. But you must take into account the context in which that statement is made. And just to draw your ladyship and your lordship's attention, that passage comes in a section of the judgment that starts in 31, where having concluded that there is no problem with the condition 14 of this consent as a matter of its express terms, the court and Lord Hodge goes on to consider the possibility of whether they ought to have implied a term into the condition. And everything that follows, including that statement, is all about whether the court should imply terms into planning permission. Of course, and she rightly took you to it, paragraph 35 is where it ultimately ends up. The court will understandably exercise great restraint in implying terms into public documents have criminal sanctions attached to them. That's a quite different point to the broader principle that doubts are to be resolved in favour of the more permissive reading. And it's a much more logical one, which is that if there are criminal sanctions, one would not expect to find terms implied in that are invisible in the planning permission. But it's not the proposition on which my learned friend's submission rests, and I have already taken to you to paragraph 66 in Lord Carnworth, in which he makes reference to the criminal sanctions as a possibility. But again, that is only in the context of caution in terms of using intrinsic evidence. It is not a goal difference sort of provision of the kind that seems to be being advanced by my learned friend. So you don't get it from Trump or the higher statements of principle in terms of how you construe the planning permission. You also don't get any change out of the decision that she took you to in the Manchester case about conditions. And just to show your ladyship and your lordship what that is about, in paragraph 17, one finds the deemed planning permission that results from the inspector's decision, and one sees that what the permission that's granted is a dwelling house class C3 and 4 commercial units operating as a travel agent, so that the operative part of this planning permission says not only that these are commercial units, but also commercial units limited to a travel agent or a courier's office, or therapy, medical and treatment room. And that's what this case is all about, is the legitimacy of adding restrictions within the operative part of the planning permission rather than by means of conditions. And one sees at paragraph 45 how this plays out. There's a reference to the I'm your man, in which the principle is stated that if you're going to produce a limitation on an accepted planning use, you do that by means of a condition. And it goes on to refer to the Lambeth decision in the next paragraph, where the point was that permission was granted for a DIY store, but again in the operative part of the permission, it purported to restrict the DIY store to sale of non-foods goods, and the point is that you do the latter restriction by means of a condition rather than in the operative part itself. That's all it's saying. So converting that to our sort of planning permission, the operative part should be for a live-work unit. You ought not to find a live-work unit for use in classes use B within the operative part. If you're going to impose that further restriction, you do that by means of a condition. So that is all that the question of conditioning is dealing with. Once you've got the established planning use, warehouse, dwelling, in this case, live-work unit, any further limitations on the way in which that established use is to be performed in this case go into conditions. So there's nothing there that supports my learned friend's goal difference approach. She describes my construction as a mandatory one and suggests that the nature of planning control is that it doesn't positively oblige you to do anything. I agree with that, but all planning permissions function in that way. The point here is whether the permitted use is one use or both uses, as I say. So she doesn't get anything out of the suggestion that mine is a mandatory sort of permission. And then she says, well, the final basis upon which she suggests that you ought to lean in favour of the more permissive approach is that there is uncertainty about the nature of the meaning of work, and that her interpretation is less risky because it means that you don't have to work. That, in my respectful submission, is one that presupposes that the reasonable reader would effectively give up on the idea of, give up on the work element of live-work, and in some way be encouraged by the notion that a given occupant could retreat away from live-work use and simply use the flat purely for residential purposes. But I say that doesn't work as an argument. You do have to, the reasonable reader would, and you have to grasp the nettle and decide what work means. And once you've done that, that eliminates the element of uncertainty. And even on her construction, this property has to be capable of, and has been authorised to be used for work purposes. So I suggest that what Malone and Friend is encouraging is something of a cop-out in terms of the analysis and the meaning of the live-work provision. So for all of those reasons, I say that you mustn't start with any preconceptions, that there is no automatic or default winner in this contest, and that there is no basis for starting from the proposition that this could be used, could be interpreted as live and or work, to suggesting that it should, unless I'm able to produce indications that dislodge her from that starting premise. Moving on to business.
Can I just ask you, I mean, you accepted, I think, that linguistically at least, live/work is capable of meaning live and or work.
I do.
So you're my lawyer, I'm looking at this lease I'm about to take on and it says live/work, and I say to you, that's ambiguous. Tell me what sort of factors might help me understand what I can and can't do, or what I'm obliged to do there. Wouldn't you say, well, the first thing as a lawyer operating this field I would tell you to do is to look for the conditions attached to the planning permission, and there aren't any. And so, since there aren't any, why do you reach the conclusion that you can only live in one part and can only work in another part, neither of which, as a matter of fact, your final point would be, are defined?
Well, we've touched on this before lunch. I don't accept the proposition that the conditions is the only place in which one finds a limitation on the permitted activities within that can go on within the subject property.
Where else would I?
Well, one has to construe the operative part first to see what it authorises, and it is perfectly capable, as a matter of language, of meaning live and work, and construed against the SPG for reasons that I shan't revisit. That is the obvious meaning, and the answer to the question, well, what about conditions, is that in this particular planning permission, we are the live and work use, which is the meaning of the term that appears in the operative part of the permission, does not prescribe use class B1 businesses as the only business you can carry on, and therefore the logical, the outcome of that is that you are not so restricted, so you can carry on any business. Likewise, when it comes to, well, what is the explanation of the absence of a condition saying that the business must go on in the northern half or the southern half, the answer is that is up to you. And conceptually, there is no problem with that. And once one then takes into account the SPG and all of the provisions that are talking about employment and business and so on, that is the more natural conclusion to draw, as distinct from one which involves, I say, throwing the baby out with the bathwater and saying, well, this must be a live and or work permission that could be used just as a flat. That simply flies in the face of the SPG, and it is suggested of me that there's no hint of my, there is no hint of the SPG in my planning, my reading of the planning permission. Well, there's absolutely no hint or support for the and or reading in the SPG either. So, Lord, I say that if you are advising the if you were the reasonable reader were receiving advice, I'm not sure if one is building on the metaphor too much here, but if they were receiving advice, the correct advice would be in London Borough of Southwark planning permissions, construed against the SPG, the term live work unit is intended to designate live and work, and the absence of the conditions merely means that you have a freer hand than you would otherwise have done in terms of where you carry out your business and what the nature of that business is. So that's my answer, Lord. Business. I was disappointed in my learned friend's submissions. I hope she'll forgive me for saying in the context of work, because I challenged her. I threw down the gauntlet to say, if my reading of business is not right, what is work? What is the wider concept of work? What are the parameters of work? And how does one judge what is within and out with work? And she has not supplied you with that, other than to assert the broad statement, work is a wider concept. It should be given its natural meaning. The meaning of the label work is wide, but she's made no attempt to explain what the limits of that concept are. And I say that's telling, because it reveals rather neatly that that it is very difficult and indeed more problematic to read work in that way, because one just doesn't know. And how would the local authority investigate and make some form of determination? And how would courts make a determination as to whether the work element of this planning permission, which arises on her construction, is or is not being complied with? The fact that nobody else has been able to come up with a working definition, you'll excuse the pun, of the wider concept is indicative that it's not right. And although my reading of business is criticisms that could be levelled at it, it is the only available candidate, and it is the best of the available candidates. My learned friend sought to excuse her failure to provide any explanation of what work means by saying, I'm not the one that is doing the suing. My client is being sued for breach, not the other way around. That, my respectful submission, is completely irrelevant. The meaning of the planning permission can't alter or change or be fudged by reference to who is the one who's seeking to enforce the obligation against the other, or who sued whom. You simply got to grasp the nettle and make a decision about what it means. Finally, she says that I'm cherry-picking in the extracts from the oral evidence. I don't accept that criticism. The only other matter to which my learned friend refers to that's not covered in the excerpts that I've given you relates to the investing of the second respondent's personal funds, and Judge Johns dealt with that and said, well, that's managing your own finances. You're not investing other people's money. You've not got clients, and he rejected that notion. And then, in any event, if my learned friends had felt that that was important evidence that you would bring to bear when making a fresh determination of breach in light of the correct construction of live work, they could have provided that material to you. And finally, Jenkins, I fully accept that's a 1954 Act case. Nevertheless, it is a 1954 Act case in which the court engages with what we mean by business. And in my respectful submission, it is instructive and indeed consistent with what you already, normal expectations of the meaning of the word, that they regard business as being activities carried on with a view to profit. Not necessarily obtaining profit. Learned friend gave the example of an artist starting out who may or may not make money in the early months, but it is activities carried on with a view to profit, and that's the working definition that I would commend to you. Lady, my lords, unless there's anything I can assist you with further, I'm grateful for your patience.
Thank you very much indeed. Well, thank you all very much indeed for all your helpful submissions in relation to this matter. You won't be surprised to hear that we're going to reserve our judgments I can't guarantee precisely when they'll be handed down, but we're conscious that everyone's anxious to get a result as soon as it's practical. They will be sent to you in draft in the normal way. That's for typographical, grammatical and minor factual errors, not as an opportunity to re-argue the case, please. Now I draw your attention, I think you're probably all used to it now, but the new embargo or newish embargo, that we are taking that extremely seriously, and it is most important that our drafts are not disclosed to anyone other than those that are on the list, which you will provide according to the embargo terms. I'd hope thereafter you'll be able to deal with any other matters in writing. If you can't agree an order, we'll hear submissions in writing. Thank you all very much indeed.
All rise.